Okay, part 2 on cracking the code, maintaining fiscal integrity. Okay, the sovereign from Bouvier's 8th edition, the sovereign, whether the term be used with respect to a state or to the chief ruler of one, is accorded an immunity from suit in courts of justice. This doctrine obtains both in England and in this country. It is a general rule that the sovereign cannot be sued in his own court without his consent. How is it that any such claim of right can be made by these parties? Why must we obtain permission before suing each other or suing either of them? The answer for these questions reveals a tactical source point of current physical, mental, and spiritual dilemma facing mankind. Here we go. Appellation. Appellation, a rather obscure word in the English language, is defined as follows. Appealing, appeal. The action of appealing to a higher court or authority against the decision of an inferior one, the appeal so made. B, grounds of appeal, title, claim. Number 2, the action of appealing or calling on, entreaty, or earnest address. Calling, designation. 3, the action of calling by name, nomenclature. 4, a designation, name, or title given. A particular person or thing. B, a class, a description or connotative name. So that's Oxford's English Dictionary, 1971. Number 1, a name or title. Number 2, the act of naming or calling. So these are other standard dictionaries, international editions. From Webster's Collegiate Dictionary, 5th edition, 1947, the act of calling by a name or designation. Appellation is spelled identically in both French and English. In French, the word means appealing, calling, naming, appellation. It's a French-English dictionary. Through this word has come our way through French, its ultimate origin in Latin, appellate onis, accosting, appeal, calling by name, title, pronunciation. Burt's Latin English Dictionary, 1926. The word accost appears prominently in the Latin origin of appellation and is defined as to speak first, address, greet, manner or act of addressing, greeting. Funken Wagnalls. Standard Dictionary of the English Language, International Edition, 1958. Okay, so this and other French words made their way into the English-speaking world courtesy of the Norman French attorneys accompanying William of Normandy, aka Duke of Normandy, and William the Conqueror. Following the inglorious Battle of Hastings in England in the year 1066 Anno Domini, the corrupted French dialect of the Normans was then immediately installed in the legal system. The Englishmen, unlearned in the new language, that is to say nearly all, were thereby effectively foreclosed from any adequate legal defense of themselves and their property against the tyrant king esquires. Esquires are just attorneys. So the tyrant king's esquires in the courts, and so experienced economic annihilation. As with many other impediments in the language of the legal system, Norman French attorneys are at the bottom of the obscurity of the word appellation as well. Of the first 4 definitions of appellation in the Oxford English Dictionary, hereinafter OED, Oxford English Dictionary, the world's most respected lexical authority, we are told that 3 of them are obsolete, or obs, period. So obsolete, the only valid one being 1, that is to say, the action of appealing to a higher court or authority against the decision of an inferior one, the appeal so made. Even those are so-called obsolete usages. Even though the so-called obsolete usages are in complete harmony with only modern definitions, the reason proper usage of this word is labeled obsolete by the King's Esquire on staff at Oxford English Dictionary. The reason this word is not defined in law dictionaries. The reason most people believe that an appellation is nothing but an archaic synonym for a name. That is to say, a Christian appellation. The reason people generally have a reverse conceptual understanding comprehension of the meaning of this obscure term is the same reason that Big Brother calls himself or itself a sovereign and you a subject, and why you must first obtain permission from the Crown and the United States before suing, political subjugation, and compelled allegiance, another word that Norman French origins. As can be seen from the etymologies and definitions above, appellate is the Latin root for an appealing to, a calling out to, a pronouncing of a name title, an accosting, a speaking to, addressing, greeting of another. The idea of the name is a secondary, derivative aspect. Consulting the original Latin meaning and later French usage, the essence of an appellation is the action of making an appeal or calling out or addressing another, that is to say, an act for getting another's attention. One makes contact with another by emitting an appellation. Even when considering as a name, an appellation is not a crippling ball and chain claim on your existence. As a sovereign, your appellation is merely your cue or signal that someone is reaching out and desires communication with you. That's interesting. This is why the so-called sovereigns, the Crown and the United States, require that their approval be obtained before the suit is initiated. Okay? They evaluate the appellation and decide if they want it. Sadly, most people have identified with their name and believe that when it is called, they are obligated in responding as requested or ordered, as though use of the name somehow exerted control over their freedom of locomotion and the disposition of their personal property. This is wrong-headed by those who control the publishing of textbooks and newspapers and dictates over government, the media, and the legal system have nevertheless successfully inculcated this infirmity into our collective consciousness. A name is a piece of property and can even be copyrighted. You are not your property or not your name. An appellation differs from a name in that it is something that originates with another. It is an earnest plea for communication. The so-called obsolete definition 2 in the Oxford English Dictionary is the true modern meaning of the term. That is to say, the action of appealing or calling on, entreaty, or earnest address. Others use an appellation for addressing you, accosting you, calling out for you, making an appeal of you, and getting your attention. And what you do follows such appeal is entirely your own choosing. Okay, so they are calling out to you. It's like they're offering something for you to do something. You don't have to do it. When someone makes an appellation for the purpose of taking legal action against the Crown takes note of the appellation, so you're calling out to the Crown, and issues a decision. Any sovereign must agree that he can be sued and that he is liable before another can proceed against him. So they're calling out to you, and then you must agree. Okay, and this is true for any sovereign, including you, irrespective of any lack of awareness on your part of your own omnipotence. People in America have lost sight of the fact that they are sovereigns and that nothing can be foisted upon them without their agreement. This is a fact of life, not an invented truth of this text. No one can be legally victimized without his or her consent. However, we have been beaten down by the legal system with such vehemence, taxed and robbed with such righteous fervor, and brutalized and even killed by officers of our own government with such callous indifference for so long that people have lost sight of who the boss is and who the servant is and who they really are. A name is a piece of property. It is not the living, breathing, flesh and blood man associated therewith. When someone asks for your name and you give it to him, you voluntarily surrendered your property and consensually agree that whatever he wants to do with it. In the case of a judge, this can be extremely dangerous. All the different names you have gone by throughout your life are simply means of addressing you, ways of calling you, and have no more importance than you accord them. If you choose to respond when someone uses your property, that is to say your common law copyrighted name, to get your attention and then go into contract, that is your sovereign, self-determined choice. So you have a choice whether to determine if you want to act on them calling you. You don't even have to do anything. But I'm sure there's more paperwork involved as to rejecting a call. Take a look at the following exchange. Judge could just as easily be replaced with officer, detective, or agency, etc. Judge, what is your name? No, it is not. What do you mean? I mean, what is not my name? I am asking for your name. Well, I have lots of names. Which one are you talking about? I'm talking about your real name. What is it? My parents call me Son. My friends call me Lefty. My dog calls me Woof Woof. These names are very real to me, and I usually respond to each. What name are you interested in? I'm not interested in playing word games with you, and you will show respect for this court. Are you John Henry Doe? The name you just mentioned is common law copyrighted property, and I am the owner of that particular property. In fact, I have given public notice of my ownership of that property by publishing in the newspaper. If you want to use that piece of property again, I need to inform you that there's a fee for its use set forth in the copyright notice, and it's a fairly steep fee, but I will waive the charge you just incurred if you elect not to use it again. What would you like to do? I don't know what you think you're doing, mister, but you're about to get into deep trouble. Mister is not one of my names. Look, whatever your name is, I am commanding you to identify yourself or be held in contempt of court. Bailiff! I apologize for the misunderstanding, because I am certainly not my intention to show contempt for the court. I am only interested in protecting my property rights. Are you commanding me to surrender my private property for your use without compensating me? I most certainly am not. I'm merely asking for your name. Well, my name is my property, and I do not give it away. No, I do not give away any of my names for the use of others without being compensated in accordance with the use fees as published in my copyright notice. As far as I can tell, the only reason you want my name is to use it so the court can make money. Is that correct? That is not correct. I need to know who you are so we can proceed with the business of the court. You bring up a good point. If you do not know who I am, then why do you want to do business with me, and why are we here? You are testing my limits of my patience, sir. Give me your name. You want to know what to call me? You want to know what to call me. That would do fine. You can call me Secured Party. This is not going to go on much longer, my friend. Very well, Mr. Secured Party. Where do you live? Well, I live in the confines of my skin. Judge dropping his head in his hands. What is your address? I don't have an address. See for yourself. As I slowly do my 360 spin, holding my hands around my body. Where do you sleep at night? Sovereign. In a bed, usually. Sometimes in a sleeping bag. I mean, which building do you sleep in at night? Like I said, I don't sleep in a building. I sleep in a bed. Sir, Secured Party, whoever you are, you can have a seat over there and we will take up this after lunch. Nothing got started and nothing ever got started, even after lunch. The sovereign was truthful and respectful the whole time. He never gave away his private property for the use of the court, who could open an account and lodge pecuniary charges on it, pecuniary, over relating to money. The sovereign kept his cool because he knew that the only thing the judge wanted him to do was voluntarily surrender his private property for the use of the court, without compensation. The judge knew that the sovereign understood what was happening, and so gave up. Once you understand that this is all that is going on in a courtroom and elsewhere, then you will be able to think on your feet and make the right moves too. The world runs on the initiative of about 5% of people. Well, that's about the target audience of this manual. The rest need orders. The consensus of the other 95% on the subject of one's relationship with the government, banks, tax agencies, courts, and corporations, all separate realms, is defective in that such inert abstractions have been accorded superiority over living beings. Governments are transitory mental contrivances set up by a clever few for the purpose of living off the efforts of the trusting many. A generalization, yes, but also the truth. That you may have at some point lost sight of the fact that you are sovereign is not a denigration of who you are. The entire population of this country, of this planet, has been systematically shafted through inconceivable complex mechanisms in the field of commerce, law, and finance by the same small tribe of brilliant, psychopathic madmen hell-bent on its subjugation. You cannot disparage yourself because you fell prey, along with others, and were betrayed by those whom you placed trust. But you can begin dealing with the situation from the proper viewpoint, and that is as a self-governing, fully accountable, responsible man or woman who can control and is in control of his or her own political economic destiny, despite the apparently overwhelming odds stacked against you, knowing that you are not your name, that you, the sovereign, can take legal possession of your name in all of its forms like any other piece of property, and that the option of accepting or rejecting any appellation from any party that comes your way is strictly yours in your sovereign capacity, which speed your course. will speed your course. The real-life, proven, practical solution contained in this handbook are humbly tendered for assisting you in accomplishing these aims, actualizing your true nature and enjoying the realization of your dreams. Unrevealed obligations. Here we go. There are 60 plus million statutes on the books and over 3 million different law books on file in the Library of Congress. Your straw man and you, by default, as surety, is responsible for knowing and complying flawlessly with the letter of the law in every single statute in existence. Because everyone is presumed to know the law, and ignorance of the law is no excuse. If the word manipulators can claim the legal title of the straw man with which you are presumed contractually unified, decide that they will tax, fine, regulate, rob, incarcerate, and possibly even kill the abstract straw man, then you, the physical, biological being, go along for the statutory ride and experience the consequences in reality. In such legal status, you are devoid of capacity for asserting and enforcing any rights. You have no standing in law. A slave cannot sue his master or owner. Through other such governmental legal fictions, with penalties for things as innocent as paying your straw man's Social Security payroll taxes, accepting free delivery of mail from the U.S. Postal Service, and taking out licenses issued in the straw man's trade name. Otherwise, sovereign men and women are unwittingly set up to have their lives utterly being destroyed by Big Brother or voluntary contracting as a surety for the straw man. As it turns out, the straw man is also responsible, or jointly and severally, with all of the straw man debtor Social Security account holders for the payment of the national debt, thereby making any man or woman with a Social Security card in his or possession equally liable as a co-surety for payment of the national debt. The Social Security account is the straw man's account and is listed in your straw man's trade name, not your true name, and is in Helvering versus Davis, 301 U.S. 16, 1957, Supreme Court 81, LED 1307, 1904. You read it. The U.S. Supreme Court ruled that the Social Security is neither an insurance nor a retirement program, but a welfare program. Because of this fact, application for and use of a Social Security account number, SSAN, for one thing, is a tacit confession that one is so incompetent in managing his or her own affairs that he or she must appoint the U.S. government as his or her guardian and seek eligibility for welfare payments. Such defective status is also known as by other names such as child of the state or ward of the court, and is legally known as the doctrine of parens patriae, wherein the state is considered the legal parent or guardian of those under disability and unable to care for themselves. When you pay the first penny of the straw man's Social Security payroll taxes, you executed the contract and confirmed that the straw man and you by default as surety was a child of the state incapable of managing its own affairs and needful of guardianship. Also, in Fleming v. Nestor, 363 U.S. 603, all that, read it. The U.S. Supreme Court ruled that those who have paid in Social Security taxes over their lifetime have no vested interest in Social Security, No vested interest means the payment of the Social Security benefits from the Social Security system is optional or discretionary and not obligatory. Thus, by law and by contract, when a Social Security taxpayer retires, FICA, Social Security system has no obligation for compensating the retiree taxpayer. This is another reason why Social Security is an unconscionable bargain contract. Well, if I'm paying in and I actually have no vested interest or obligation that they have to pay me that back, it's not an investment in yourself. It's giving to a welfare system. All of your accounts, certificates, securities, licenses, permits, etc. are in the name of your Ensley's strawman trade name. All accounts are the strawman's accounts, not yours. You are the surety attached thereto, and the party that everyone goes after for payment and specific performance because, between you and the strawman, you are the only one with the warm breath capable of fogging a mirror. You are a sitting duck waiting to be blasted until you rectify this situation. And this is where the concept of redemption enters in. Subsection: doing business under your trade name. Corporate names, corporately colored names, trade names, marks, trademarks, and service marks are private property of someone, and all can be claimed as such. Government accepted custody of the name or property when the newborn was registered via the original birth record or document. The strawman was born on the first document admitted by the government that referenced the name, if not on the original recount document itself. Sometimes the initial document is a Social Security card. Sometimes it is a certificate of live birth. There are literally dozens of variations of the birth certificate, as harmless as hospital birth certificate and profound as Department of Commerce and even Federal Security Agency birth certificates. However, because everything about you is notated, registered, assigned, listed, vested in the name of, and accessed via the strawman's trade name, all property is considered the strawman's property for purposes of acting out of the charade that anyone other than the state owns anything. However superficial this policy may be in terms of what actually transpires when a citizen finds himself in one of Big Brother's shakedowns, it is nonetheless an essential public relations tool for maintaining order within the flock, as individual sheep are cornered and shorn. In terms of finance, commerce, and law, the entire planet actually functions in a mirror image world of reality, anchored by private money that represents liability, not substance. For example, like Federal Reserve notes or FRNs, ferns. We all live in a corporate bubble, literally the Federal Reserve International Monetary Fund plantation. The government, a bankrupt front and sham entity for the Federal Reserve IMF creditors, has no other way of doing business with you and managing the account ledgers other than by using the name of the artificial person contrived from your true name set in the capitals abbreviated. True name, initial capital letters only, de jure, solvent, sovereign, flesh and blood, American citizen, creditor. De jure. That's flesh and blood you. All caps, abbreviated trade name. De facto. That is the citizen of the United States. That's the bankrupt subject, ink on paper, debtor. So de jure is flesh and blood you, natural person you. De facto is trade name person you. Under the current paradigm, there is no other way the industrial community can do business with you And that is all it is, business and commerce. Your trade name is the name by which all of your products and services are identified and known in commerce. Trademarks. Trademarks are defined as a word, phrase, logo, or other graphic symbol used by a manufacturer or seller to distinguish its products or products from those of others. The main purpose of a trademark is to guarantee a product's genuineness. In effect, the trademark is a commercial substitute for one's signature. Interesting, okay. So when it's got like the Walmart brand, it's going to guarantee the product's genuineness. So Walmart's got a lot of trademark names that are distributed under, like on the electronics it'd be On, other things like that. In food, I can't remember what it is. Maybe like great price or something, or best value or something like that. Anyways, your true name cannot be classified as a word, phrase, or logo or other graphic symbol because it is constructed in accordance with the rules of English grammar. Your true name corrupted into an all capital letters format, however, eminently qualifies as a word, a phrase, or logo or other graphic symbol, and also a commercial substitute for one's signature, because such an assemblage concoction of letters cannot be defined, classified in any other way. The all caps realm is a corporate realm and none other. Common law trademark is defined as one appropriated under common law rules, regardless of statutes. That's Black's 4th edition. This is why you need not consult statutory law and secure approval from any governmental agency in appropriating or claiming and enforcing a common law copyright on your trademark or your trade name. Your services your services, that is to say your labor, are delivered, billed, and paid for via this trademark service mark, which encompasses everything about you in the world of commerce, because it is via that entity that commercial interface is achieved. Interesting. So when they say my name, they're going to say they're going to get an image in their mind of the genuineness and they're going to get the genuineness of my product because of my, where do we go here? Okay, there we go. So, this is why you need not consult statutory law, because you don't need or secure approval from any government agency. Okay, your services are delivered, billed, and paid for via this trademark, service mark, which encompasses everything about you in the world of commerce, because it is via that entity that commercial interface is achieved. When you lost the gold pack currency, we lost personal accountability and took our corporate limited liability. We lost the capability for extinguishing and terminating a debt with substance or gold, and took on the mechanisms for merely discharging a debt, placing the debt in limbo or suspension with privately owned liability instruments or Federal Reserve notes. Your trade name, trademark, is your ticket for doing business with the modern bankrupt industrial community and uniquely identifies all products and services brought into existence by your hand. Your only real shortcoming was that you were unaware that your trade name and trademark was just that. You have been conducting your life as though you were dealing with the other true name, sovereign men and women. when in actuality, both of you and the people you have been dealing with have been operating via a camouflaged, corporately covered artificial person, trade name, trafficking in privately owned, valueless Federal Reserve notes. The reason that all industrial communities computers have only all caps capability for displaying the names of customers should now be clear. Okay, subsection sovereignty. Now let's read this thing real quick. The use of the trade name is as old as commerce itself. The conventional trademark is a part of what is called the symbolism of commerce. Okay. The proclaimed value of Federal Reserve notes is their so-called purchasing power, which amounts to nothing more than people's collective lack of awareness of the con. For a very brief period in history, Federal Reserve notes could be redeemed for lawful money, but that facility vanished with the lawful money. Federal Reserve notes can no longer be redeemed for anything of value, including the debased token metallic coins in currency. People have confidence that Federal Reserve notes will continue being accepted in exchange for items of substance. So substance is like physical stuff. So people keep accepting Federal Reserve notes in exchange for the goods and services they offer. The only value of the Federal Reserve note is its prospect for being accepted by the next guy in the exchange for the goods and services he is selling. Federal Reserve notes are fiat by decree, money issued by the holders of the monopoly on the medium of exchange, and penalties for their use are enforced via military and quasi-military measures. Okay. Sovereignty, supreme dominion, authority, or rule. Sovereignty itself is, of course, not subject to law, for it is the author and source of law. Sovereignty. The Federal Reserve is not an agency of the government. It is a private banking monopoly. The policies of the monarch are always those of his creditors, said Congressman John R. Rarick. Congressional Record, February 1st, 1971. The dilemma of operating in today's political environment pans out like this. Almost every government in existence has been bankrupted by the same small tribe of Luciferian shysters, and the notation of a trustworthy, principled, and self-determined politico is a subject reserved for the history books. As Congressman Rarick so astutely pointed out 30 years ago, the actual sovereigns are the creditors in finance and commerce, not the national puppets promoted on TV and in the newspapers. The disinformation circus run by the media, also a controlled monopoly of the money power, is an indispensable component of the global con because the Federal Reserve creditors are so few in number they could easily be exterminated, so they believe, if identified by even a small segment of the population. People must be made to believe that the governmental leaders are acting autonomously with the best interests of the people at heart, if the scam has any chance of enduring. When a sovereign borrows and accepts credit, he or she takes on a creditor, and the creditor inherits supreme claim over the sovereign's realm. The laws of the U.S. government are the policies of the Federal Reserve and IMF creditors. Officially, corporately, legally, and otherwise, politicians are now even called policymakers, instead of just their original spurious moniker, lawmakers. Public policy is the watchword and credo of all U.S. political and judicial or legal undertakings. The creditors dictate over the full spectrum of governmental activity in America with an iron fist, from the highest office in the land all the way down into a governmental activity as apparently mundane as parking tickets. That is the leading source of revenue for all major and many smaller American municipalities. A sovereign is the author and source of all law in his own realm, a subject of no one. Interesting. If the creditor is the one who sets the policy and makes a law, sets the policy of the monarch, it is easily discernible that the real sovereign is the creditor of the United States government, of the U.S. government, not the smiling politicians chirping sound bites and performing for the camera. How does one get established as a creditor or sovereign and become the author and source of all law with which one is associated? Answer: by becoming the sole source and arbiter of all terms and conditions of every private consensual contract under which no one does business with Big Brother and all others as well. This is an apparently tall order at first glance, but realistically attainable if equipped with the right knowledge. Consensual contracts. A member of the sovereign constituency is guaranteed many rights under the Constitution of the United States of America, 1787. Possibly the most significant paramount right is that of contracting with whomever one desires, and in such event that any obligations associated herewith shall not be impaired by any outside third party. The most widespread debilitating malady currently afflicting nearly all sovereigns in America is the proclivity for capitulating when pressured by one of Big Brother's operatives, as to say, for example, attorneys, judges, traffic cops, IRS agents, etc., and consenting in doing business under whatever terms said operatives dictates. The affliction is contracted in a number of ways, one of which is through ignorance of the true nature of modern government, a for-profit, insolvent commercial undertaking having left the realm of a de jure political operation of, by, and for the people upon the incorporation in 1871. Look up the Act of 1871. It's right in there. It says they incorporated the government. All governmental business in America today is strictly private, confirmed by Clearfield Trust Co. versus United States, 318 U.S. 366, 63rd Supreme Court, 557-1943. All U.S. law, here we go, some definitions, is copyrighted property of the following British corporations: the Thomson Group, LLC, Ltd., with offices located in Montreal, Quebec, Canada, owns inter alia. West Publishing Company, Barclays West Group, Bancroft's Whitney, Clark Boardman, Callaghan, Legal Solutions, Rudder Group, Warren, Gorham, and Lawmont. Lawyers, quote. Read Elsevier owns, inter alia, all this other stuff. Confirmed in Black's Law Dictionary is copyright British law. Ooh, that's interesting. There's a little source for you. All U.S. law is copyrighted property of the following British corporations, and that is explained in Black's Law Dictionary. The U.S. government incorporated as a for-profit commercial enterprise in the Legislative Act of February 21st, 1871. So you can just Google Act of 1871 and it'll pull it up. You can read right through it. It's like 20 pages or so, something like that. Maybe even it's 11. 41st Congress, Session 3, Chapter 62, page 419, and chartered a federal company entitled United States, or United States 1871, aka U.S. Incorporated, a commercial agency All right, here we go. Governments descend to the level of a mere corporation and take on the character of a private citizen. As an issuer of private, corporate, and commercial paper securities for the purposes of suit, such corporations and entities are regarded as an entity entirely separate from government. When an American sovereign is approached by any of the numerous kinds of government revenue agents acting on behalf of the Federal Reserve creditors, the contract is for the purpose of collecting debts. Federal Reserve notes equal debt, not lawful money. Lawful money is gold and silver coin. That's why it says in the Constitution, and not for anything as far-fetched as securing the noble ideas espoused in the Declaration of Independence and Constitution, and otherwise generally associated with the American way of life. So, lawful money is gold and silver. It says right in the Constitution, right in, let's see, under the legislative branch, Article 1, I think Section 8 maybe, Clause 17, somewhere right around there. It says Congress and its enumerated powers shall make nothing but gold and silver coin as payment of debt. So I don't know what these Federal Reserve notes are, but they are just debt. So if you want to pay a debt, you have to pay in gold and silver coin. But you will see later maybe that they did away with that in 1933. When Big Brother's hatchet men came calling, they grant you full importance and respect for the sovereign that you are, for knowing that all your actions are self-determined, and for knowing exactly what you are doing and with whom you are doing it. You see, all the government and quasi-governmental actors are just out there beating the bushes, scaring up business, and it is fully expected that you, the sovereign, are aware of this fact, giving you an education on civics and current events, national bankruptcy, non-substance, commercial script for currency, sham government, occupation by foreign military officers, unconscionable co-suretyship obligation for the debt of the U.S. government, etc., is not part of their job description. Therefore, whenever you enter into an exchange with a government revenue officer, you provide tacit consent and execute the contract established thereby. Government's paramount objective above all others is acquisition of your wealth, money, property, assets. This phenomenon is no different than walking into a restaurant, examining the menu, and then placing an order. When approached by a waitress, it is expected that you know what you are doing, that you know you are fully liable for the meal you order and consume, and that you will pay the bill when it arrives. The contract so formed is called an implied contract, and is based solely on consensual conduct. Okay, so implied contracts are based on consensual conduct rather than expressed, that is, a written agreement. If you place an order for food, you have tacitly consented and accept full responsibility to pay for it. Yep. Government-type waitresses and waiters, code-enforcing revenue officers do nothing but work the shop, patrol corporate U.S. turf. So it's like they have all this territory called the United States of America, and they're, tacitly getting us to do some consensual conduct and have an implied contract. So these guys are looking for customers, unwearying, trusty, sovereign American men and women who wander in and are not aware of the difference between de facto U.S. statutory law and de jure American common law jurisdictions, and write up orders which are eventually paid for by the customer, extorted by the sovereign American on his way out the door in exchange for the sovereign American's freedom of locomotion. Before any contractual encounter commences, that is to say, before a code enforcement operative invokes your unwitting execution of a contract, you are considered a sovereign being who can claim all protections afforded by the Constitution from the de jure government, one of which is contracting with whomever you wish. Okay? That the code enforcer does not represent the de jure government is of no consequence. You are also accorded as a sovereign respect for having full understanding of what you are getting into and with whom you are dealing, and for contracting as you best see fit. You decide on doing business with a municipal corporation in Chapter 11 reorganization is a bona fide, self-determined commercial discretion that any businessman can reasonably make, and which is warmly welcomed by those soliciting the business. The major discrepancy in the transaction is that there is no meeting of the minds, a necessary component in any valid contract. But since you are a sovereign and you nevertheless respected for any bargains you entered into, however unconscionable they may be, this all takes place, of course, in the straw man's trade name. But that is a rather moot point when one is faced with such finalities as garnishment of wages, eviction, and the business end of a loaded 38 caliber police special. The system justifies abuse of the American sovereign, indeed thrives on it, because the sovereign was duped fair and square into becoming a surety for the trade name. All right, and that'll wrap up part 2 for this section. And we will begin the cure for volunteeritis.